The Noida extension land row continues as more and more farmers are appealing to the High Court for getting their land back from the government.
Builders on their part are looking at renegotiations with authorities, including paying more money to farmers to retain lands, and home buyers are likely to approach the court for a solution.
The Greater Noida and Noida Extension land row seems to be seeing fresh turns by the hour. Noida Extension Flat Buyers Welfare Association, or NEFWA, is filing an impleadment application in the Allahabad High Court after it quashed the acquisition of 589-hectare land in Patwari and Devla village. While harassed developers and buyers pass the blame from one to the other, the losses include 20,000 residential units and 2,597 individual plots. More than 1 lakh buyers will be affected. More than 11 developers including Amrapali, Supertech, Gorsons, Arihant and Nirala will be affected. Almost 200 crore rupees have been invested in construction, and the development of schools, hospitals, IT parks and the basic connect between Noida and Greater Noida will be impacted.
We are a huge developer, we have a lot of options, and we can fight with the authority, give us a clean and distinct land so that we can settle our buyers. We cannot go against our buyer. Buyers are our fish and bread.
CREDAI, the apex body of real estate developers, will challenge the Allahabad High Court order to scrap the acquisition of land in Greater Noida. CREDAI officials met Greater Noida Industrial Development Authority or GNIDA officials to discuss ways to protect the interests of both buyers and developers. Meanwhile, more and more farmers continue to appeal to the High Court for return of land. Hebatpur and Roja Yakburpur villages are to see a decision very soon. Confused and insecure buyers are now moving to adjoining areas like Rajnagar Extension and Faridabad that was so far overlooked due to the high demand of home buyers in Greater Noida. Tanya Basu, Bloomberg UTV, New Delhi.
Well, it's a fairly critical issue. Joining us now on the final word are Pankaj Bajaj, President of the Industry Association, CREDI, and Supreme Court lawyer Amir Singh Pasrish. Let me begin with Amir first. Thanks for being with us. Amir, you know, the big question is that why was the land allocation cancelled? Was there a legal lacune? Was there a procedural flaw? Why did Allahabad High Court and Supreme Court, on what grounds have they cancelled it?
Well, Pranjal, there's a huge lacuna, and I think it's something that needs to be understood in the context of this 1894 Act. It's not a new act. It was meant for taking over land practically forcibly from people at a time when land didn't have such a value. It had a section 4 that used to come into force, and then a section 6, and you could take over the land. Then in between we put in the opportunity to object. Now the opportunity to object can be overridden by something called the urgency clause. Now this is in section 17. The effect of the urgency clause is that you bypass the citizen's right to object to the acquisition of his land, and if you bypass that right, you are effectively bypassing what the Supreme Court has held in many cases to be a constitutional right. Now, akin to a fundamental right. So if it's akin to a fundamental right and you choose to bypass it, when is that power to be exercised? We've got some 50,000 acres of land being taken over for planned development in accordance with a development plan that was published earlier. We're proceeding in the slow, elephantine machinations of government. We don't have to do things in a tearing rush, but we'll deprive the citizens of a 30-day right to object for the takeover of their own land, and we'll do it, as has emerged in that judgment of the Supreme Court, because the section 6 was imminent at a time. We had to do it in a hurry under the industrial acquisition process. Now supposedly this land is required urgently for industrialization, and then shortly thereafter we're going to change it into residential use. Now the Supreme Court found a disconnect between those two. The fact that it was industrial use converted to residential use, and invocation of urgency, which they have many times held should only be used for things that are really emergent, like the changing of a, if a river changes path and doesn't flow down the same water course, and because of floods or something you need to acquire land urgently to build a dam or something to save lives, then you call it urgency, then you call it emergency. But otherwise you don't use Section 17, and if you do, it's going to be a very uphill task to justify that.
All right, Pankaj, let me bring you in here as well. Were the developers aware of the procedural problems existing in the Greater Noida and Noida Extension land acquisition?
No, not at all. We were not aware. We bid for these lands, the members of CREDAI bid for these lands as they would bid for any other government land. And as with any other government land, we did not get into the antecedents of the land. It was a government title, so we assumed that everything would be all right. It is not for us to investigate the title and the procedure that the government or the authority adopted to get that title. So it is something that we came to know.
I mean, you explained that. You explained that, Amir, and we saw how Pankaj is also talking about that the developers were not aware of these procedural lacunae. It's only come up now. But today, as things stand, the question is what are the rights of all the stakeholders, the developers and the consumers, the buyers of those plots? What can they do now?
The Supreme Court has said, and it is hard to believe, that the developers couldn't have done their due diligence. This is in their judgment, that the developers were fairly aware of the process that was being followed. I personally, forget about being a lawyer, I find it difficult to believe that we need to go with such tearing speed and such great rush to sell flats to buyers even before the acquisition is over. So if we're going to be acquiring land and the acquisition is going to be underway, surely we should sell it after it is acquired.
Right. Pankaj, what are some of the possible solutions now going ahead? What are the procedures that should be and can be followed so as to avoid such a situation arising again in the future?
See, there are two separate issues now. One is specifically for the Noida extension, and there's a general issue of land acquisition. I think going forward, various state governments have come out with various models. All of them are now banking on mutual consent route between the farmers and the acquiring authority for land acquisition, and that clearly is the way forward. The government of UP itself has come out with a very progressive land acquisition policy. They've said that for any project to go through, 70% of the farmers of that area have to agree to that project, unless otherwise the project would be scrapped. If 70% agree, the balance can be acquired forcibly, of course after giving objections, but they would also have to be given market prices. This or variant of these models are now being adopted in various states. In the Noida extension case, the situation is now messy. They would have to either go for fresh acquisition proceedings or something called the Karar Niyamavali provisions of the government of UP, which again means mutual consent. We are awaiting communication from the authority as to how they would proceed.
I mean, you talked about the fact that procedures were flouted and the land was acquired in a way which does not really sit well with the law. Now, can the aggrieved, which is the developers and the buyers, go to the courts, either Allahabad High Court or Supreme Court, and force the government to compensate them because the government's acquisition of the land was not correct?
Yes, they certainly can go to the court. Whether the court gives them relief is the question of finding whose hands are stained and whose hands are clean. You might find that the buyer's hands, the flat buyers are relatively unstained, and if you look at that Supreme Court judgment, you will find that the developers were somewhat knowledgeable in terms of knowing what they were up to and thinking that they would manage to get away with it. There is a side of this which is simply defeats common sense. Forget the law for a second, which is that you're paying 5% down, you're allowing this kind of concession to the builder as the initial installment. You don't match that with the market price that is given to the original owner of the land, the farmer. In fact, the market price is slowly pushed backwards the moment a Section 4 acquisition happens, because the price is set by the Section 4 notification on that day, not on the day of payment. So we can keep, looking at justifying all this. We need to amend the law, firstly. Secondly, if we do go back to the courts with the existing law and the mess that is already existing, there is serious need for the courts to pass directions which actually are very difficult to do without an existing law. Perhaps Parliament can step in and make some kind of special law in this case. That is a possibility. That could even be the UP legislature. But the question is, right now, as things stand, you want to ask the court to do a balancing, which is like cut the baby in half. And I don't think it's very easy to do with the law as it stands.
Right, just a final word from you as well, Pankaj. If the authority or the government doesn't come up with a solution in terms of returning land to builders or rehabilitating them elsewhere, then do the existing buyers stand the risk of losing their property altogether?
I hope not. If there is no land, obviously there are no homes. We have to get the land to provide them the home. If there are no homes, then the question arises, can we refund them the money? Obviously, we would like all our members to refund the money. Some of our members are maybe smaller in size than the others. They may have invested all the money that has come from the customers into the projects. The buildings may have come up. So I do not know how fair it would be for them for anybody to expect them to refund the money at at a very short notice with interest. It would have to happen on a case-to-case basis.
Well, thanks for that, Pankaj and Amir. As you heard, the industry is saying very clearly that if they don't get land, there is no way that they could possibly compensate the buyers. But this is an ongoing issue, and we'll be coming back to both of you gentlemen as the situation progresses. Thanks very much for being with us this evening. Now, the battle of succession at the Hindu seems to have ended in an anticlimax. 4 top editorial officials of the 132-year-old newspaper have resigned from their positions, protesting against the appointment of Siddharth Varadarajan as the editor of the newspaper.
This is a battle that has spanned nearly 15 months. The battle to succeed N. Ram at the Hindu as editor-in-chief broke out last year when N. Murali's elevation was